Bismillah ar-Rahman ar-Rahim. Your Excellencies, distinguished guests, ladies and gentlemen, Assalamu alaikum. It is an honor and it is a real privilege to address you at this very special event, at what is on any view a very special moment in the development of dispute resolution in the Kingdom. Keynote speeches such as this frequently begin noting the widespread adoption and endorsement of alternative dispute resolution, and in particular, international arbitration. One would generally note that there has been a widespread acceptance of arbitration as a form of dispute resolution. Its geographic spread has increased year on year, whether it's north to south, east to west, and across cultural divides. And its scope of application as a mechanism has also expanded beyond one's original contemplation. It used to be just small-scale contract disputes, and now arbitration is really an umbrella term for many different types of dispute resolution, covering many different fields of activity, from shipping, construction, insurance, commodities, energy, telecoms, foreign investment, banking, public international law, the Olympic Games, Formula One, and so the list goes on. One would also note, characteristically in keynote addresses such as this, that the area has produced an almost unique international consensus on how the procedure should be structured. It is an international system of justice, and it's structured by way of essentially three foundational documents. These are the fundamental norms that structure the field worldwide. Firstly, 1958 New York Convention on the Recognition and Enforcement of Foreign Arbitral Awards. Probably the single most successful private law convention ever. It now has 160 contracting states, and it sets the basic norms for the process. Secondly, the 1985 UNCITRAL Model Law on International Commercial Arbitration, the key guidance for what a national law on arbitration should look like. Now there are 111 jurisdictions around the world that have adopted laws based or enacting the UNCITRAL Model Law. And thirdly, the 1976 UNCITRAL Arbitration Rules. They are the key standard for arbitration rules, for ad hoc, and also now institutional arbitration. So those three documents are really the foundation for this international consensus. Everybody now agrees that this is the gold standard. And when one talks about promoting new and emerging arbitral seats, like the Kingdom here, when one talks about attracting foreign direct investment, when one talks about enhancing the economic progress of a country, including, for example, the Saudi Arabian Vision 2030, it is this international consensus that we have in mind. So states or jurisdictions that are emerging in this field, like the Kingdom of Saudi Arabia, must meet this gold standard. They've got to join the field in order to satisfy users' expectations. Indeed, this gold standard has been formalized in many places, notably by the Chartered Institute of Arbitrators in its 2015 London Centenary Principles. The Chartered Institute set out a checklist of 10 criteria which any new arbitral seat should meet in order for it to be effective efficient, attractive, successful. Those 10 criteria really articulate the basic international consensus. They include, I won't go through all 10, because that would be cruel on you as an audience. I shall go through only some of them. It includes, for example, a basic modern international arbitration law that reflects the norms in the UNCITRAL model law, that protects party autonomy, that restricts court intervention, that makes the arbitration process effective, final, and binding. Secondly, an independent judiciary that will not interfere in the arbitration process. Thirdly, legal expertise. Fourthly, education of all those actors involved, arbitrators, judiciary, experts, users, and also enforceability. There's no point in arbitrating unless the end result is an enforceable award. So that, amongst others, are the London principles. That is the gold standard that every new arbitral seat has got to achieve. The international consensus goes further. It's not just New York Convention, the model law, the UNCITRAL arbitration rules. There is now a very large network of what we call soft law. That is regulation by arbitral institutions and other dispute resolution bodies that have published guidelines on best practices. In fact, there are hundreds of such guidelines now that have been published. They're called protocols, rules, codes, models, guidelines. They set out what is the best practice for most aspects of international, commercial, and investor-state arbitration. And they reflect, again, the international consensus. In fact, one sometimes refers to this as almost like a medical condition, that people feel compelled to produce guidelines all the time. We live in a world in arbitration of maybe too many guidelines. And if you are entering this field as a newcomer, it can be bewildering, the number of small booklets that you have to read to understand the process. Now, having stated that there is an international consensus, I want to, with you, pause, take a step back, and look at the nature of that consensus a little bit more closely. There are three overlooked but fundamental aspects of this consensus. I'm going to go through each one. Firstly, the consensus actually consists of two different levels. There is a fundamental level, and there is a second different level of consensus. I will explain this. The fundamental level consists of the norms, the actual underlying structural norms of the field. That is the New York Convention and the UNCITRAL model law, a convention and a model for national legislation. Those aspects are the framework for the practice, the actual practice of arbitration. And that is a real international consensus. Those documents and those norms are critical. You cannot have a successful arbitration center internationally unless you meet those basic norms. And Saudi Arabia now does, because it's implemented the New York Convention and it has a law premised upon the model law. But that's the first fundamental level. The second level in this international consensus is actually not about the legislative framework. It is about how arbitration is actually practiced within that framework. What does arbitration actually look like? When you refer your dispute to your arbitral tribunal, what process will be used? What will the hearings look like? What will the written stage of the process look like? Now there, one's not looking at the fundamental norms. One's looking at an international consensus that has developed over the last few decades, which is within that structure. There is a consensus. When you step out of your own local system and move into international dispute resolution, there is a general consensus as to how to structure arbitration. But it is a slightly odd consensus, because when you look at how arbitration is actually practiced internationally, in the main, not always, but in the main, it is actually the Anglo-US model. It is an adversarial model with aspects, limited aspects of civil law practice. That is the consensus that people are now feeling compelled to join. It is very different to the inquisitorial model that you will be familiar with, for example, with domestic arbitration, as I understand it, in the Kingdom of Saudi Arabia. The adversarial model puts the tribunal in a very different position to an arbitrator acting inquisitorially. Now, the reason for this, there are many reasons, but in part, the adversarial Anglo-US model is an answer to the problems of local domestic arbitration in inquisitorial systems. You will know better than me, but I am told that there are many problems with the old inquisitorial model. Arbitrators who are not neutral, arbitrators who fail to properly case manage, where there is delay, where there is not a proper fair hearing as between the parties, not a proper equality of approach. So what is this international consensus that I'm talking about? What does it look like? The Anglo-US model, essentially. It has a number of core components, which I will set out. Importantly, the tribunal is established as a neutral body that stands above and apart from the parties. That's the theory of it. So the tribunal waits to be educated by counsel. That's the philosophy. The tribunal starts with no knowledge of the case. And then, as the arbitration progresses, the tribunal will be educated about the case by counsel. That education will be through a phase, a written phase, and then an oral phase, and sometimes a further summation written phase. So that's totally different from a tribunal acting proactively, making the inquiries himself or herself, and actually shaping the process himself or herself. An English commentator, actually German, F.A. Mann, famously described this model as the principle of unpreparedness, because the tribunal is not expected to be that prepared, because the tribunal is receiving the information from counsel. Now, that model, by the way, I mentioned there were 3 points I'm making. That's the first point. Should be a way of some relief that we've covered some ground, and there are only 2 points left. So that's the international consensus at this second level at the moment. The second point, that model, the Anglo-US model, is undoubtedly successful. It has cured many of the problems that exist in the local domestic inquisitorial system. But the key point I wish to make to you is that it is not without problems itself. The Anglo-US model is now subject to much criticism worldwide. I have said that keynote speeches such as this begin normally by praising the success of arbitration. But if you look at conference programs all over the world, after the keynote address, you have a series of panels and sessions. And in those panels, people then criticize the fact that arbitration is too expensive, that it takes too long, that it is not sufficiently flexible, that it actually is not a good alternative anymore. So we have this paradox. We are selling an international consensus about a particular procedural system, and yet that same system is subject to much criticism now. So the main point to focus on here is if we are looking for a gold standard, if we are looking for a system of arbitration that, for example, should be used in the Kingdom of Saudi Arabia, which will attract international acceptance, which will attract people to come here to resolve their disputes, should we simply sign up without question to what is now regarded as the golden standard? Should we simply replicate what is done in other countries by way of procedure? I would urge you not to. Because in the short term, if you simply adopt an Anglo-US model that is in general usage, you may be hailed as a jurisdiction that complies and conforms with all other major arbitral jurisdictions. But in the long term, you will have more and more conferences with people complaining that the process is too long, it's too inflexible, it's too expensive. So why go down that route that other jurisdictions have gone down? The answer is not simply to replicate. The answer is to innovate. And that is a point which many new arbitral jurisdictions entirely miss. The difference between replicating, copying what is now done elsewhere, and innovating. That is trying now to answer the problems that are expressed worldwide with international arbitration as a process. Now, to make that point good, I want to address the real, actual practice of international commercial arbitration worldwide, and briefly, the practice of investor-state arbitration under investment treaties, to show you where this international consensus is vulnerable. Where does it break down? Why is it that it gets criticized even though generally it is very successful? So this is what you will not find in the textbooks that are selling international arbitration. This is a slice of practice, actually what it's like in the field. Let me first consider commercial arbitration. And I can go through each of the components that characterize the Anglo-US model. International commercial arbitration frequently begins with what is called procedural order number 1. That's because it is the first procedural order. And the PO1, procedural order number 1, sets up the framework for the process. Now, in an ideal world, according to the textbooks, the tribunal would understand the particular characteristics of the dispute in front of it. What are the needs of that dispute? What process is required to most efficiently resolve it? Because arbitration is flexible. That often happens, but not always. Because what also happens is that overworked international arbitrators who have taken on too many cases do not have time to actually consider the specific characteristics of the individual dispute. And so they go to their computers and they press print. And what comes out is their standard procedural order number 1, which is used in every case. Standard procedural order number 1 undermines the whole idea of flexibility in arbitration. Because there shouldn't be a standard. It should depend on each individual case. But we suffer in this field from standard forms. And indeed, some institutions even endorse standard procedural orders. Secondly, the Anglo-US model includes some civil law components. The first one is exchange of full written memorials, that's statements of case. Now, a full statement of case has become an undisciplined document because it's an opportunity for lawyers to put down all information about the case, everything. They tell the whole story as a matter of fact, the whole story as a matter of law. Every conceivable issue they foreshadow and they cover just in case. That can be effective, can be efficient, can also be ineffective, terribly inefficient, and incredibly expensive. Smart law firms around the world, specializing in international arbitration, can spend a vast number of billable hours producing hundreds of pages of written submissions. Just to make clear, when I mention law firms, none of them are the sponsors of this conference. Obviously, none of them would do this. But others do this. And the problem is, this then increases the costs massively. It becomes a lengthy, expensive, and cumbersome process. The Arab legal yardstick, khair al-kalam, dalla wa dalla, is apparently, thank you, is apparently not so understood in the world of international arbitration. And this is then reciprocated because the other side receiving a 300 or 400-page memorial will produce the same. The client would expect it. And so you have a mass of written material that has not been focused or directed. What happens after that? Actually, the same thing happens again a second time, because you will have a reply, and then you will have a rejoinder, another reply. Everything that could possibly be said about the case has been said. This presents an inequality of arms for the tribunal, because the tribunal is not a law firm. They do not have hundreds of legal assistants. Legal assistants working in windowless basement rooms for weeks on end. Legal assistants who haven't seen their family for a long time. Tribunal doesn't have that. So how does the tribunal deal with all this material? It arrives in boxes in the arbitrator's room, and often it is extremely difficult to manage. This will increase the costs, make the process more cumbersome. Having gone through the written phase of memorials, you will also have, sometimes integrated with it, document production. This is a big area of the practice of international arbitration. People will exchange lengthy lists of documents that they want produced. We produce something called a Redfern schedule, after the famous English arbitrator Alan Redfern, which is a system of making requests for documents. And this process tends to take months, and it tends to produce a mass of material, which often is not very helpful, or doesn't actually get looked at by the tribunal in the end. Again, it's an element in the process which is vulnerable. When it works very well. But in general practice, it is a point where many people will raise criticisms because it adds to the costs, because it makes the process more difficult to achieve with any kind of efficiency. And then we have witness statements, another key feature of the Anglo-US model. A witness statement, you would think, is a statement of a witness. That's what you think. It's the witness writing out what he or she will say in testimony. It should be the statement of a witness, Anybody who has practiced in international arbitration knows it is frequently not the witness statement. It is the statement of the lawyers prepared for the witness. Now, witness statements have a very important role in organizing oral testimony, in making sure that witnesses actually have a proper hearing and that their testimony is properly considered without any last-minute surprises. But when it's drafted by law firms, none of them represented here, they become written submissions. They become almost as long as the statements of claim and reply themselves. Even when you see the witness at a hearing, and he or she is unable to speak clear English, and yet the witness statement is produced in beautiful, perfect English, with perfect spelling. How can this be? The point here is that it's a vulnerable part of the process. There are ways to structure it properly. If it's not structured properly, it can then lead to many other complications and problems. Now, the same can be said for expert evidence. In the Anglo-US model, parties would generally use their own party-appointed expert rather than a tribunal-appointed expert. Again, this is an answer, a good answer to many problems in domestic arbitration, where you have a tribunal-appointed expert and parties do not feel that they've had then a fair hearing, or the expert process itself is not really expert. Many other problems exist. But there are vulnerabilities here as well. You will be amazed how you can find in this world an expert on any issue who will say anything, especially if the price is sufficiently attractive. We call them hired guns. And in an expert process that's not working to its optimum, you will have two opposing hired guns. How does that place the tribunal? Well, in a difficult position. Each hired gun is cross-examined by counsel. Counsel who, by the way, is not expert. In the end, it can be quite complicated to bring all of that together for a tribunal in an efficient, effective way. It can work, but it is vulnerable as a process. Then we move from the written process into the actual oral hearing. Now, this is odd. Having spent months, sometimes years, putting together the case in a written form, we switch to an oral hearing where counsel has the opportunity, orally, to say it all again. So the tribunal, having received all this information in writing, now hears it orally. You may question why. There are good reasons to have an oral hearing, but it is vulnerable again to excesses if it's not properly controlled. You will then have cross-examination of witnesses, which is an Anglo-US feature specifically, and cross-examination of experts. Cross-examination is not known in many systems around the world, but it's formed part of this international consensus. It is part of the standard now. It is a gold standard. People expect there to be cross-examination. That is good news for common law practitioners like me, because we feel needed in all these cases. It is not such good news for people who are not common law practitioners and have to learn cross-examination. When it works, cross-examination can be incredibly useful to actually unpack witness statements, to get to the truth, to dissect out what has been put in a statement by lawyers and what is really the position, to test the evidence. But when it's not done under a properly controlled form, it can take a long time. It can be not so helpful. It can be expensive. And it can then give arbitration a bad name. If you draw, then I should just complete the steps. You get through an oral hearing. At this point, all issues have now been covered in writing and orally. And yet what we now have in the Anglo-US model, increasingly, is automatically post-hearing briefs. Post-hearing briefs is another opportunity to set out the case in writing by reference to the testimony that has been given during the hearing. Again, it can be very useful as a summation of the process to focus the tribunal on what the evidence actually is now it's been heard. At its worst, it is another opportunity for law firms to put their associates into basement rooms and tell them to draft for weeks on end. And another 100-page document, 200-page document is given to the poor tribunal. If you wanted to start this process from scratch, if you had a blank piece of paper, if you were told, without any history, design the best dispute resolution system, would you design this system? The answer is you probably wouldn't. It's not obvious. It's got a history which explains it. There are good reasons if it is a cure for the problems of domestic arbitration, but it may not be the optimum. And you can add on to that compounding issues such as a lack of diversity of arbitrators, very few from the Middle East in particular. You can add to that questions about ethical standards and so on. Now that's commercial arbitration. I want to say a brief word about how this all works in investor-state arbitration, which is a growing body of practice, of increasing concern to almost every country, including the Kingdom of Saudi Arabia. Investor-state arbitration. These are disputes arising out of investment treaties, bilateral investment treaties, and regional agreements. In short, these treaties involve two or more states agreeing to protect and promote investments from the investors of each other. So one country and another country agree to protect investments coming from the other side's investors. The treaties set out international standards of protection. They also generally include an arbitration clause, which allows an individual investor to bring an international claim in arbitration against the other state. This is a very unique process. You, as an investor, can arbitrate directly against a foreign state if your investment has been harmed. This is the new phenomena. It's given rise to a huge range of arbitration practice. Now, what is very curious about this is that these disputes have been squeezed into the international commercial arbitration model. The type of arbitration that is used is the same as for commercial arbitration. But the type of disputes are very different. These are not horizontal disputes between a contractor and another contractor. These are disputes by investors vertically against a state, questioning the exercise of sovereign discretion, questioning state policy. That's the nature of this. And if you question state policy, you might not just affect your own rights, but you might affect the whole community. You might affect everyone. So questioning this kind of governmental conduct actually has a much, much bigger significance in a country. You would think that the arbitration process would take that into account because it's flexible, because it's adaptable. So we would have an arbitration mechanism that allows for other people to come and make their case, for a broader spread of interests to be considered. But actually we don't. We use the same Anglo-US model. And that has given rise, to other concerns. It's put pressures into the system. People are unhappy about how the arbitration process works. UNCITRAL is now looking at reforming it because it may not cater for these specific needs of this kind of dispute. So I've spoken about the international consensus. I've identified two levels of consensus: an underlying legal structure, which must apply everywhere. But secondly, a consensus about the actual practice of arbitration, which is questionable. My third point: given that there is a serious danger in simply adopting that second level consensus without any critical review. And I'm urging a jurisdiction such as this not to do that. That doesn't mean rejecting the Anglo-US model at all. What it means is looking at it critically in order to take into account its vulnerabilities. It is an answer to much of the problems of domestic arbitration, but in itself, it is the subject of debate. And that debate, there's no reason why a jurisdiction such as this, it's a debate where you should be involved. You should be innovating in order to come up with a process that meets these problems, that actually predicts the vulnerabilities now. Don't just sleepwalk into this process. If you sleepwalk into it and simply say, we will do as every other country, then you will be having conferences in 5 years' time, like we have everywhere else, with people complaining about the process and saying, how shall we improve it? How can we actually make it more efficient? And this has become more acute, much, much more acute, because now there is possibly serious competition for arbitration. There are other systems of dispute resolution that are trying to break into this field. We have, for example, the Singapore International Commercial Court, the first of its kind, a court in Singapore that is acting a bit like the International Court of Justice for states. It is a court that anybody can use around the world. They can have what looks like arbitration, but in a court structure which is much, much more disciplined, much tighter, with stricter rules, that's maybe faster, maybe more efficient. We've got other commercial courts that are springing up all over the world. Some in this region, of course, DIFC in Dubai, the Abu Dhabi Center, Qatar, in Kazakhstan. We have English language commercial courts that are now rising up all over the world, trying to benefit from Brexit. That is, to take business away from the London Commercial Court. English language commercial courts in the Netherlands, Germany, France, China. We have mediation. Mediation is becoming a serious competitor to arbitration. In particular, now we have the Singapore Convention. The Singapore Convention allows for a mediation which gives rise to a final, binding, enforceable result. That is new. That could be a challenge. Instead of arbitrating, if you want a final, enforceable result, you can now mediate. And so we actually have to consider how we will keep arbitration competitive. So in conclusion, my message is, if one wants to take a critical health check of arbitration, one needs to look critically, not just at this region of the world, but internationally. We need to look critically at the international consensus. We need to think about innovation. Innovation is not just blindly adopting what is done elsewhere. So now is the moment, hopefully with enhanced education, with training, to think collectively and laterally to bring about an arbitration process that actually meets the needs of users. And this is what arbitration is in its nature. It is flexible. It is adaptable. It's supposed to be alternative. That means it should not be automatic. I'm going to risk my position with another Arabic expression. Kharq al-ada, break habits. The breaking of habits is something significant in many fields. But actually, in international arbitration, there are many habits that need to be broken in order to be reviewed afresh. We are all well placed to do that together. I urge it upon us, and inshallah, with that, there will be success in arbitration in this area of the world. Thank you very much.